Hello everyone and welcome to today's Mondac webinar in association with Hasseltine Lake Kemper, who will be providing a practical guide to trade secrets and the strategic considerations to maximize value for your business. My name is Dan Sampaio and I'm joined by a wonderful panel to take us through today's discussion. Jamie Rowland has over 20 years of experience advising on protecting and enforcing clients' valuable IP rights. Jamie has experience in all areas of IP law with a particular focus on dispute resolution. Whilst his primary focus is patent litigation, he's regularly advised clients in relation to confidential information and trade secrets on both contentious and non-contentious matters. Gemma Robin handles a wide variety of software and telecommunications subject matter with a particular emphasis on artificial intelligence and machine learning, drafting and prosecuting patent applications in the fields of reinforcement learning, transfer learning and distributed learning, as well as applications of probabilistic graphical models, control theory and optimization. Frances Wilding started her career as a patent examiner at the European Patent Office in Munich. At HLK, Frances has continued to work across a broad variety of fields, including mobile telecommunications, healthcare, medical and display technology, including user interfaces, simulation systems, data centers, design and implementation of neural networks, and business internet-based inventions. Joseph Lempel specializes in obtaining and managing patent portfolios in the pharmaceutical and chemical industries. He is a particularly experienced in EPO oppositions and appeal proceedings, acting for clients in patent matters across a diverse range of technologies, and has also led patent proceedings in the intellectual property, enterprise court and court of appeal. Now, before I hand over to the panel to begin today's webinar, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. The panel will endeavour to answer as many as possible, but any questions we don't get to will be sent on to the panel who will be in touch. It's now my pleasure to hand you over to our panel to begin. Thank you.
Hi everybody. We're going to start with a very quick reminder of trade secret law. So the 1995 TRIPS agreement was the first international convention with express provisions relating to trade secrets. And it established a trio of requirements for trade secrets that can now be found in the majority of trade secret legislation around the world. In the EU, these requirements were introduced by the Trade Secrets Directive of 2016. Which imposed a harmonised standard for protection of trade secrets across EU member states. The three requirements, as set out in the directive, are summarised on the slide, and they provide that a trade secret protects information that is secret, has commercial value because it is secret, and has been subject to reasonable steps under the circumstances to keep it secret. In the UK, the EU directive was implemented by the Trade Secrets Regulations of 2018, which sits alongside the UK's common law of confidence. Outside the UK, the same trio of requirements for trade secret protection are common to nearly every implementation of trade secret law. In EU member states, national legislation has been introduced to implement the EU directive, although the way that countries have included the directive into their national law does differ from state to state. In addition, each state tends to add its own particular take on how exactly the directive is implemented, based on their pre-existing statutes or common law. In the US, all federal and state statutes concerning trade secrets include the same three elements, as does China's trade secret law. Japan also has similar requirements, and so there is a good deal of harmonization across jurisdictions. In addition to the key elements required for trade secret protection to subsist, other characteristics of trade secrets are also more or less harmonized, at least among European member states. Firstly, trade secrets are both transferable and licensable, although care should be taken to ensure that the information is not disseminated too widely within the relevant industry, as that can pose a risk to the perceived secrecy of the information. Co-ownership of trade secrets is also possible, and to be considered as a co-owner, the person concerned must have legitimate control over the trade secret. Trade secrets are enforceable under national law, and in Europe, while national laws implement the EU directive, the directive makes clear that a trade secret owner can rely on wider protection than is granted under the directive, where that wider protection exists under local law. In the UK, for example, principles established under the old common law of confidence remain applicable. Trade secrets are infringed by their unlawful acquisition, and the usual range of measures available under local law in cases of suspected infringement of IP rights are likely to apply. This may include, for example, measures to allow evidence of infringement to be gathered, including evidence preservation orders and orders for disclosure, and final orders, such as orders to cease use of the information, prohibition of production or sale of products, seizure of goods, and financial compensation. In order to enforce a trade secret, it will be necessary to demonstrate that the information concerned met the requirements for trade secret protection to subsist. And a key part of this will be demonstrating that the information was subject to the relevant reasonable steps to keep it secret. Jamie will be looking at this in more detail later. When it comes to enforcing trade secrets, it's worth remembering that while trade secret laws are territorial, in practice, their enforcement doesn't conform to territorial limitations in quite the same way as, say, patent enforcement does. Trade secrets arise when information meets the relevant requirements, as I just set out. The similarity in those requirements across jurisdictions often means that when a trade secret arises, it may arise in many countries around the world at the same time. Trade secrets are not, therefore, inherently tied to their place of creation, their place of storage, their place of use, or any other geographic location. Likewise, misappropriation of trade secrets might occur anywhere, and it doesn't necessarily need to occur in the same country in which the trade secret was created, or in which the trade secret owner resides, or in which the trade secret is used by its owner. Of course, there are limits to international conformity on trade secrets, and while many countries do provide for misappropriation actions, litigation involving cross-border parties and conduct can be complex and really quite challenging to pursue. So, as we've already covered, any information that meets the 3 criteria for trade secrets can be protected as such. And I've set out a few examples of different types of information that you might want to protect on the slide. Trade secrets can be useful both for long-term strategic information and also for information that has more short-term value, like results of marketing surveys or pre-launch product information. Even information about what not to do can be extremely valuable. If it's the result, for example, of extensive research establishing that a particular development option is not actually viable, that's still incredibly valuable and can be protected as a trade secret. Trade secrets can protect information that is technical or non-technical, and the information may also be susceptible to other forms of protection, including copyright, database rights, design rights, and patents. I'm going to focus for a moment on patents, as while a customer database, for example, might be protectable both as a trade secret and with database rights. For technical information, it's generally necessary to decide between either protection with a patent or maintaining the invention as a trade secret. Deciding whether to use patents, trade secrets, or some combination of both to protect any given innovation will generally require an approach that's specific to the particular circumstances surrounding that innovation and its use. But there are some key considerations regardless of the technology concerned, and I've highlighted these on the next couple of slides. Firstly, is the innovation actually eligible for patent protection? Does it fall foul of any statutory restrictions? What are your chances of proceeding to grant with commercially valuable claim scope? And would any eventually granted patent withstand litigation? It's important to think about whether the patented invention will be detectable. Less of an issue for mechanical inventions, but for software and other technology that might be hidden when in use, will it be possible to infer patent infringement? This could, for example, be via reverse engineering, targeted querying of a system, or through commercial or technical information made available to the public. On the subject of reverse engineering, it's worth remembering that this can be a defense against trade secret misappropriation. So the ability to reverse engineer your invention might point toward favoring patent protection, both in terms of detectability of patent infringement and the usefulness of trade secret protection. The flip side of defectability is, can the technology be kept secret? If commercializing your product means disclosing at least part of the information, then trade secret protection is unlikely to be a viable option. You also need to consider whether you may be required to disclose the invention as a consequence of regulatory requirements, to demonstrate compatibility with a standard, or perhaps in connection with raising funds. Even if you're confident that the innovation won't be disclosed, might it become generally known? Is this maybe addressing an issue that could be the subject of publication or research by competitors following independent development? Finally, it's worth thinking about the life cycle of the innovation in question. Trade secret protection arises immediately, while patent applications take time to progress to grant, but they offer 20 years of protection. For a foundational technology that may be exploited for years to come, this is likely to be more than justified. But the investment of patent protection may not be worthwhile for a technology that is quickly brought to market, but may also quickly be overtaken and become obsolete. So just a quick summary of the essentials. For trade secrets, you need to ensure that the three conditions are met: secrecy, commercial value because of the secrecy, and reasonable steps to maintain secrecy. There may be additional local hurdles to consider, so do check local law. And finally, it's sensible to look at trade secrets as part of a combined IP strategy, identifying the information that's most appropriate for trade secret protection, given the particular circumstances of the information and the priorities of the business, and then taking the necessary steps to ensure that protection is maintained. And with that, I will hand over to Frances.
Thanks, Gemma. I'm taking the first of our sector-specific examples, and I'll be looking at trade secrets with a focus on AI. We thought it would be useful to start with an idea of to what extent trade secrets are used in practice for AI innovations. What do we see from some of the larger corporations? IBM is an example here. They, and in particular Dario Gil, who's director of IBM Research, said at the beginning of this year that they are de-emphasizing patents. He said, when it comes to the most promising fields in tech, AI, cloud, security, semiconductors, and quantum computing, innovating requires deep focus. These fields are so dynamic and complex that we need more hands on deck for each breakthrough. Increasingly, this requires balancing trade secrets and patents alongside a style of R&D called open innovation, in which teams from various organizations and institutions collaborate with both internal and external players. So this shows a move towards trade secrets in conjunction with other IP strategies. Even more interesting are reported cases of enforcement of trade secrets in the AI area. There was the Uber and Google settlement agreement early in 2022. Briefly, Anthony Lewandowski, who was a pioneer in the Google self-driving project, left Google and started his own company, Otto, which was then acquired by Uber in 2016. This acquisition led to a trade secrets theft lawsuit that pitted Waymo, which is the former Google self-driving project, against Uber. Lewandowski ultimately lost his position at Uber and faced criminal charges and a civil lawsuit. This case was finally resolved with Uber paying Google a substantial performance of the almost $180 million which Google was awarded in arbitration in 2019. So big bucks. You may also be aware of the recent case of Neural Magic vs Meta Platforms Inc., which was brought in Boston and settled in August 2023 this year on confidential terms. The lawsuit contended that a former Neural Magic scientist, Alexander Zloteski, who had joined Meta, transported vital algorithms to improve efficiency of computations and use larger data sets. Neural Magic said that Meta published the algorithms on open source website GitHub and publicly thanked Zloteski for solving a key problem for its continued advancement in the world of artificial intelligence. So we can see from both company policy and actual enforcement that trade secrets are definitely used in AI areas. In fact, some people might think that AI is the perfect technology for trade secrets. Firstly, even an expert can't usually understand exactly how an AI model works to give a good prediction of an outcome, so that makes the inner workings inherently easier to protect with secrecy. Secondly, you can even allow customers to access an AI model while keeping the source code confidential and on your own server by selling AI as a service, which is accessed over the internet. Now, that's a common way of commercializing AI, and both these factors make it easier to keep innovations secret. Thirdly, AI is seen by some as simply not suited to the patenting system. Many AI innovations are challenging to patent because software and mathematical methods are excluded from patentability by the statutory exclusion of these things in patent laws. So you need to try to avoid the exclusion in your patent claims in order to get a granted patent. And this makes the chances of getting a patent granted lower than for other technologies. Also, even if you do then get a patent, the kind of black box nature of the technology and the way it can be sold without revealing underlying concepts can make detectability difficult. It's difficult to see who might be infringing your patent so that you can enforce it. And these factors might dissuade you from use of the patent system, particularly because a patent application is automatically published after 18 months. So protecting the AI innovation by keeping it secret could be viewed as the better option. But there are 4 factors that make use of trade secrets more challenging in the AI sector. I'm going to look at each one of these in turn. Firstly, open source. Open source libraries are really widely used in machine learning, particularly in the circumstances when known models are applied to new problems, which is quite common. But even really core AI inventions may use a combination of open source libraries for basic building blocks and bespoke code for the innovative aspects of the idea. It may be possible to keep proprietary code confidential while also using open source software. But the extent to which this is an option will depend on the terms of the relevant open source license. The more permissive open source licenses like the BSD licenses or the MIT placed few restrictions on the legal use of the software, so you could try to keep derivative works secret. The more restricted open source licenses, the sort of copyleft licenses like GPL and MPL licenses, typically allow for modification and sharing of the software, but may require any derivative work to be distributed under the same or equivalent open source license terms. So in those cases, you literally couldn't keep your innovation a secret. It's also worth mentioning that the software community in general can have an open source and sharing mindset that can lead to practical difficulties in implementing a trade secret strategy, and that also ties in with the next challenge. Often we see software development outsourced to contractors, and this can make it more difficult to protect trade secrets. Our slide here sets out a few suggestions to keep in mind when working with external contractors for AI projects. Firstly, ownership of any IP developed by or in conjunction with a contractor should be clearly established in the contract. In this context, in particular for remote contractors, be aware of specific national law in the jurisdiction where the contractor is based, and data privacy laws may be relevant as well as laws of ownership. As I said before, it's also worth mentioning that many software developers will come to a project with a mindset that's focused on collaborative approaches, favoring contribution to open source tools and software. And this can include, for example, open source machine learning libraries and frameworks that the developers are in the habit of contributing to as part of their work. So they may be less familiar with the need for confidentiality and how to identify and document an innovation. They may not know that some open source licenses allow development of IP, and they might even want to insist on sharing their developments externally. So it's sensible to plan ahead of time how you're going to identify inventions arising from projects with software contractors. You should consider adding trade secret policy and documentation requirements to the contract and providing templates or other aids to documenting inventions. And this documentation can have a dual purpose in supporting any development that becomes a patent application, as well as documenting any development or data that you decide to retain as a trade secret. So you might choose to go ahead with both trade secrets and patent applications, even for the same development. For example, a data set might remain secret while you choose to patent a neural network training method that uses the data set. Of course, for commercial reasons, you might want to be able to disclose your innovation to the authorities, your customers, or for advertising. I wanted to talk about some times where you might be forced to disclose something that you want to treat as a trade secret in order to trade. And the first point here is regulation. I've got some regulation listed here, and it's worth saying that the first two acts listed here are yet to come into force, but they're certainly on the horizon. The requirements of the EU Data Act could be important for AI. The scope of this act is still very much up for debate, but the drafts suggest that this could force a lot of data into the public domain because it seeks to improve user access to their own data, for example, on IoT, Internet of Things devices. And this could assist in reverse engineering AI models used in the background. Moreover, it's likely to include provisions which provide access to data to enable interoperability between devices. Now, it does mention that information subject to trade secrets is only required to be disclosed under specific confidentiality arrangements, but the data would still be disclosed and make it more difficult to remain secret. As I say, this is in draft for now, but it could be one to watch. Of course, if the invention is in the field of AI, it's worth considering the AI Act, which is further along on the regulatory process and is likely to come into force by the end of this year or maybe the beginning of next year. And this EU Act deems some applications of AI to be high risk, and those are to do with safety. Some AI systems could be potentially damaging to society if they were biased, for example, providing access to published services using AI or financial credit, this kind of thing. And for these circumstances, there will be times when the data must be disclosed. And so the requirements of this act might mean you can't keep your invention secret, and in that case, patenting might be the better or in fact the only option. Regulation is also coming in other jurisdictions, with several EU member states also working on national provisions. In the UK, actually, public organisations are already subject to the UK Algorithmic Transparency Reporting Standard, meaning they have to be open about how algorithmic tools support decisions. And importantly, in the US, a bipartisan Senate committee has recently set out a proposed framework for a US AI Act, which looks at AI risk, accountability, and transparency. So watch this space. That was regulation. Our next one is standardization. So disclosure may be needed to provide to prove compatibility with a standard. And AI is likely to creep into many different standards because it's useful in so many areas of technology. The first three standards shown here are European standard setting authorities, and they between them are responsible for many areas like chemicals, consumer products and packaging, electrical equipment, apparatus, and telecoms. And the last thing there is a lot of AI work coming our way in 5G, let alone in 6G. On the second line, we can see the ISO, which has published a huge number of international standards covering almost all aspects of technology and manufacturing, including IoT. Of course, IoT is a big topic, and the IEEE, based in New York, has standards covering IoT as well as computer networks. You can see the breadth of scope for these standards here. AI may pop up in all of them, and if your innovation is to get into the standards, then it will have to be disclosed. So a brief summary here. Trade secrets are indeed already used and enforced for AI, as we've seen, in conjunction with other IP strategies. AI developments might be seen as particularly suited to being kept secret because they can be exploited without user access to the code and they're difficult to patent. But there are a few extra challenges here, as listed on the slide. So now I'll hand over to Joe, who'll be talking on trade secrets in his area of speciality.
Thank you very much, Francis. So yes, I'm going to talk about trade secrets and life sciences. And as a nice bridging passage, I'd like to start by talking about AI in life sciences. So this is obviously a new hot topic in the area, and in fact could be the subject of a whole webinar. But I'll just briefly touch on it by saying, it is an emerging area, and it can be viewed in terms of what's core AI, and in other words, the underlying machine learning methods and whether to keep those trade secrets. And then perhaps more of interest and the normal way that we look at it is the applied AI. So the result of that machine learning method, and if it's a therapeutic, a small molecule drug. Now, it's interesting to look at some of the patents that have been drafted in that sphere already, some of which say very little about AI, and you would only know that they are drafted or created by AI by the company that's created it. Now, what's key is to bear in mind sort of that it's not just one or the other, core AI, applied AI, but there are considerations. A lot of this is driven by the data set, and the data set is often one of the factors that has huge value within the business. And a key area is to look to see how much information we would need to provide in an applied AI patent application of that data set and even of the algorithm without giving away the trade secret. So that's a really interesting area that is emerging in the patent law, and that we haven't any particular cases that have come up that have discussed that, but that's definitely one to look for the future. So just reiterating, I think Gemma's point of absolutely kind of needing to develop this parallel patenting and trade secret strategy. So moving on, just wanted to go through some examples in the life sciences. So this first set of examples are generally kind of, as Gemma again talked about, the whether to patent or not to patent, that decision process. And this isn't necessarily specific to life sciences, but I thought I'd illustrate it with life science examples. And generally we kind of see two categories. The first is where it's an improved manufacturing process. And these are processes that generally, they might have used cheaper reagents or have an increased yield for improved synthesis or purification. But a patent to the method alone may struggle with enforceability of those method claims. And so quite often we have this discussion of to patent or trade secret, often coming down on trade secret side. The second is often also associated with sort of new methods, but actually it results in an improvement in the end product. But in fact, through various reasons, we may not know exactly what the underlying principle of the improvement is, what is causing that. And so it may be that yet the sort of product as a result of that improved process isn't yet definable in the standards required that we believe to get secure, robust patent protection. And again, we may park sort of it as a trade secret for now, with the knowledge that perhaps it could develop onto patent protection in the future. So with that, I'll move on to the second batch of examples, and that is really looking at the things in your business which have value by being secret. And again, I provided just 3 examples, and these are in fact examples linked to 3 US cases. So I'll discuss those in turn. The first is a case where it's a Genentech dispute. So an ex-employee of Genentech allegedly leaked some information to a biosimilars company, and that helped that biosimilars company to provide standard operating procedures. I think it was 90 to 100 standard operating procedures, and that gave them a real leg up and accelerated the development to help them to get the GMP certification, good manufacturing practices. So what's interesting from this case is that standard operating procedures might be low down on your list of things to consider, but actually they can have huge value. The other thing to note was that the receiver of the information as well as the giver of the information were sued and in fact convicted and given jail time and fined. So again, it's we'll talk about Jamie will talk about some of the reasonable steps that can be taken to kind of protect those procedures. The second example I wanted to talk about was this Keytruda Merck case. I mean, I have to admit, Merck isn't actually mentioned in the criminal proceedings, but this is a director of medicinal and scientific officer who left Merck, and Keytruda is mentioned as one of the key drugs that's the information is leaked to another company. And again, this is alleged to be providing clinical trial information relating to Keytruda and some other drugs. And so it's really kind of crucial that, again, this information is clearly marked as confidential, and processes are put in place to make sure that everyone knows that they are, to hopefully satisfy the reasonable steps. So finally, a related case in sort of subject matter wise is the last case, so Teva versus Apotex. And in fact, this is a bit more of a story there. So in fact, one of the directors of regulatory affairs at Teva was having a romantic relationship with the CEO of Apotex. And there were some emails that were leaked. There might have been, verbal communication between the two, given the relationship. And this was in fact a civil case brought between Teva and Apotex, but named the two individuals as co-defendants. And again, this was one mention was emails with the regulatory bodies, which really helped or could have been used to help approval of the biosimilars. And in fact, it mentioned in the case is, it helps Teva's position because they had a confidentiality agreement in place with the individual, and there were lots of different policies that all covered ways to look at to make clear that the information was confidential and a trade secret. So I'll just quickly move on to very briefly talking about a practical tip that we use, particularly on the patenting or not to patent idea. And for the sake of time, I'll just quickly run through that. And that's essentially that we document inventions, whether they go on to be patented or not. We have sometimes documented them as sort of a trade secret document. And what this does is it takes the invention disclosure form and it conceptualizes the idea and effectively writes a rough first draft application. Now, it's more cost effective than a patent application because the language and the fallback positions aren't scrutinized to the same level as a final patent application, but it does provide a document that has that trade secret beyond just what has been done, but at a more conceptual level. So why do we do this? Moving on to the next slide. Well, as I said, it provides a conceptual level, but another benefit is that it provides dated evidence of what's considered a trade secret at that level, and reinforces to the employees or the people working on it that it is a trade secret and to be kept confidential. And the final advantage before I hand over to Jamie is that it provides a rough patent application draft, so that should that need to be filed very quickly, we can update it and finalize it. And with that, I'll just hand over to Jamie.
Thanks, Joe. All interesting stuff. Well, in this last section, I'm going to take a look at some practical points to ensure that when the trade secret policies are implemented, those policies ensure that not only are trade secrets usable commercially, but critically, they're also fit for purpose if it becomes necessary to enforce them in the future. I am, after all, a litigator, and so that part of the puzzle is particularly pleasing for me. So I'm going to start by taking a step back and trying to get some clarity as to what taking reasonable steps to protect a trade secret actually means in practice. it is important because a recent study of trade secret cases across Europe suggests that companies are not routinely getting this right. Since 2017, so around the time that a lot of the regulations and directives came in across Europe, the most commonly raised defence in these types of cases is that the claimants have not taken reasonable steps to adequately protect their trade secrets. And not only are these defences raised, but in the majority of cases, they're actually succeeding as well. So it is an important thing to get right. So I'm going to have a look at a couple of jurisdictions to see how they deal with this criteria of reasonable steps. Unfortunately, the UK courts haven't yet handed down any decisions which address the point since the trade secrets regulation came into force. So I'm going to have to look beyond the UK, and that will be influential, or those decisions outside of the UK will be influential to as to how the UK should deal with this issue in the future. But also looking internationally at these issues, I think is going to be useful because trade secret policies should be considered globally as much as possible. From a practical perspective, implementing a framework that is fit for purpose across key jurisdictions is really sensible. And the reason for this is that if a trade secret is misappropriated, as we heard earlier from Gemma, it could happen anywhere. And it does not necessarily need to occur in the same country in which the trade secret was created, or in which the trade secret owner resides, or indeed in which the trade secret is used by its owner. So it's really important to look globally. So with that in mind, I'm going to have a brief look at how the courts in Germany, the US and China have looked at this issue of reasonable steps. So taking the second bullet point in my slide, we're going to move to Germany. In April 2019, Germany introduced the Trade Secret Protection Act, and that effectively harmonized their trade secret law with the EU's Trade Secret Directive. As with the UK's trade secret regulation, to be caught within the definition of a trade secret, the claimant in an action or the owner of the trade secret must have taken reasonable steps to protect that trade secret. Now, in Germany, there have been a number of decisions at really quite a high level, so at the higher regional courts. And one example of that is the SRS Bosch versus BWS case, which was an appeal at the Düsseldorf Regional Court in March 2021. The trade secrets in question were CAD drawings, and it was all related to centrifuge technology. And what came out of that case and the other senior court cases in Germany are a set of guidelines that really are useful guidance in understanding this criteria of what reasonable steps are. And I'm just going to outline what they are. So what the German courts have said is the protection doesn't need to be perfect. So that's an important point. But it sort of says what it does on the tin. It needs to be that they're reasonable steps. They don't have to be perfect steps. But the important point is that it has to be adequate in light of the value of the trade secret concerned. So the point there is it isn't a one-size-fits-all assessment. The protection should be a combination of technical, organizational, and contractual measures. And what's really meant by that? So on the technical front, this could include password protection, encryption, implementing different access levels, establishing a firewall, for example. So technical solutions of protection. But it's important to remember that similar measures need to be taken where the trade secrets are held in hard copy as well. So things like keycard access, logging who comes in and out, it's about control of that information. So that's the technical side. I mentioned organizational as well. So on the organizational front, access to trade secrets should be strictly limited to those on a need-to-know basis. confidential information should be clearly marked as such. And I know Joe mentioned that a brief while ago, but again, it's a really important point. And then finally, on the contractual front, robust confidentiality obligations must exist with employees and third-party customers and suppliers. I'm going to talk about that in a little bit. So those are the guidelines that came out of Germany, and they really do give quite a helpful steer for what is meant by those reasonable steps. But let's take a look at the US. It's obviously a very important jurisdiction as well. So the US introduced into federal law the Defend Trade Secrets Act in 2016. Like Germany, there have been a number of US cases that have considered what they call the reasonable efforts test to preserve secrecy. I'm pleased to say that broadly speaking, there is a consistent approach from the US to Germany and indeed other European jurisdictions that have handed down decisions on this point. But I wanted to highlight a 2022 case, and it's mentioned on the slide. It's the Turret Labs versus Cargo Sprint case. It's a 2022 case. The trade secret in question here concerned access and use of ground handling software, which Turret Labs alleged Cargo Sprint had misappropriated by reverse engineering it. Given it was all to do with software, with ground handling software, I quite like the name of it. It was Dock and Roll, not Rock and Roll, Dock and Roll. There's a laugh for everyone. Turret Labs licensed the software to Lufthansa, who then had control of sublicensing to the relevant ground handlers, one of which was Cargo Sprint. Now, during the court case, it became clear that Turret Labs had put a number of technical security measures in place to protect the trade secrets in the relevant software. So, for example, the physical service was secured in monitored cages in a data center with restricted access. There was use of username and passwords. So these were sensible and reasonable measures. However, it became clear during the proceedings that Turret Labs had not entered into a license agreement with Lufthansa or third parties that placed sufficient confidentiality obligations on the sub-licensee Cargo Sprint. So the sub-licensee, the confidentiality provisions were not sufficient. And as a result, at first instance, the court made this fairly harsh statement saying, given the nature of the trade secrets at issue, these allegations are akin to a plaintiff having pleaded that he locked all the upstairs windows of his house while remaining silent on whether the front and back doors were left wide open. The appeal court, unsurprisingly, took a similar approach and dismissed the appeal. I think what this case reinforces is the fundamental importance of contractual obligations of confidentiality to customers and suppliers. So implementing robust technical security measures is not necessarily sufficient. The reasonable measures must be looked at in the round, depending on the specific trade secret in question. And finally, to China. Trade secret protection in China falls under the Anti-Unfair Competition Act. It is possible to protect trade secrets in China, although historically the lack of disclosure in court proceedings has made enforcement challenging because trying to evidence misappropriation can be difficult. In part, in relation to that challenge around disclosure, the highest court in China, the Supreme People's Court, introduced the trade secrets judicial interpretation. Now, a judicial interpretation from the Supreme People's Court provides guidance to lower courts, which should, in theory, be followed. It's the closest tool in China, or that China has, to affect the concept of precedent. And this particular judicial interpretation was important in two ways. First, it flipped the burden of proof in trade secret cases to the defendant if the claimant can show a prima facie case of misappropriation. And that really greatly improve the claimant's chances of success in these type of trade secret cases. Second, the judicial interpretation sets out the criteria that courts should consider when assessing whether the claimant has taken the appropriate confidentiality measures to maintain secrecy of the trade secret. So it's these reasonable steps again. The judicial interpretation is consistent with the approach in Europe and the US, and goes through many of the same points. And it's just interesting, and I've put on the slide the VMI Holland versus SafeRun case, because this judicial interpretation was looked at in detail there, and the claimant in that case very much passed the criteria test and ended up prevailing in that case. So good news that trade secrets can be enforced in China. So where does that get us? If we could move to the next slide, please. I think we can sort of summarize where these cases get to us pretty quickly. Just a couple of points to make, really. So the concept of what is reasonable would depend on the value of the trade secret. The more valuable it is, the more robust the protective measures need to be. Ensure confidentiality obligations are robust both with employees and third parties, so both suppliers and customers. Just going back to that Turret Labs case in the US reinforces this point. Access to trade secrets should be strictly limited and controlled. For example, consider prohibiting visitors on site access with any electronic equipment, or alternatively, I've seen companies applying blocking tape to mobile phone cameras to ensure surreptitious photos can't be taken on on-site visits. Security measures I've really covered. The use of encryption, etc., is fundamentally important. It needs these sort of technical solutions need to be kept up to date. They need to be revisited to ensure that they are as secure as possible, depending on the value of the trade secret. I wanted to touch on employees because, as you would have heard from Joe, ex-employees appear in a lot of trade secret cases. So it is really important that contractual arrangements and the way that employees are educated are first and foremost in businesses' minds when it comes to trade secrets. And one point I really wanted to sort of highlight was it's a bit of a two-way street when it comes to employees. Obviously, it's fundamentally important to ensure that trade secrets are protected when employees leave the business. But equally, it's really important that there's education as new employees come into a business, and that when they are onboarded, they understand the importance that they shouldn't be disclosing any trade secrets, any confidential information from their previous employer. Because there is a risk of liability to the new employer if they use trade secrets that they know or critically ought to have known was a third-party trade secret. And this was addressed specifically in a UK decision of Trailfinders versus Traveller Counsellors Limited, where 4 ex-Trailfinders employees had stolen customer information and given that information to their new employer. And the court made it very clear that Traveller Counsellors, the defendant and the new employer, should have made inquiries about the nature of that information and should have been much more circumspect before using it. The point that comes out of this is don't turn a blind eye as to where the information may have originated, because that is just not acceptable. Now, I'm conscious of time. We've got 10 minutes left. I'm going to go to my third slide for precisely 1 minute. And I'm just going to mention trade secret audits. And really the point here is that seeing the kind of increase in the importance of trade secrets in businesses, we really recommend that regular trade secret audits are carried out. They're not one size fits all. The key points of a trade secret audit are mentioned on the slide. It is really important to understand and identify your trade secrets. And from that, you can understand where they are stored, who has access. If you can put those on a trade secret register, that will be really helpful from both a commercial but also a dispute resolution perspective if that happens in the future. And on that, I will pause for questions.
Brilliant. Thank you very much, Jamie. And thank you to our entire panel, Gemma, Francis, Joseph, and Jamie, for your excellent presentations. I'm always in awe of your expertise and your ability to share that information with us. So thank you. As Jamie says, we'll be moving on to our Q&A session. We have about 10 minutes, so please do get your questions in. We've already had some fantastic questions in. So to start, would you say that the balance between trade secrets and patents is shifting?
Okay, yeah, well, I'm happy to have a go at that one. So I think it would certainly be fair to say that we've seen an increase in, say, in publicity and in interest around trade secrets. Quite possibly linked to the amount of innovation going on in the digital space, in particularly the way that's accelerated in the last couple of years. I think the possibility to monetize software and AI innovation without disclosing it, together with some of the challenges that this technology can face in the patent system, as Fran was covering, I think this is making people look closely at trade secrets. And so we're seeing companies kind of taking a really considered commercial approach to trade secrets as part of their overall IP strategy. Beyond that, I think it's just incredibly case specific. But I think this kind of growing awareness of the value of trade secrets is definitely playing into companies' decisions on how to manage their IP in general. Joe, I don't know if you wanted to weigh in on that one.
Well, just to say, I think there's been in life sciences perhaps a bit more interest to see if certain areas that have become harder, or at least there's a perception it's harder to patent. So diagnostics in the US following Mayo, Myriad, and Alice, tightening up of antibody claims and loss of functional, whether people are exploring it a bit more, whether there are actually more trade secrets on that side or not, I don't know. The other thing I would be interested to I don't have any data to support it, but I wonder if there's a reflectance in how global economy does. Trade secrets are free ostensibly, other than the measures that you put in, and so I don't know whether companies are more interested in trade secrets to make their budget go further. But but I agree on the digital side. I think that's definitely an important factor.
Excellent, thank you very much. We've had a question in, and they ask, I would like to know more about jurisdiction considerations for enforcing trade secrets. For example, where do you file a claim?
Shall I take that? Or I can start anyway. That is a big question, and it's not an easy one to answer. I think, as has been touched on a couple of times during the presentations, the sort of peculiarity with trade secrets is that they could flow out to many different jurisdictions. So damage resulting from a breach of a trade secret regulation or equivalent theoretically could happen anywhere, and it could happen in multiple jurisdictions. So the way that one would want to look at that is to, firstly, you want to act pretty quickly, but you want to try to assess which jurisdictions there is a potential problem in. You want to then assess within those jurisdictions whether there's the right legislative framework to protect the breach, the misappropriation, and then you want to try to ensure that you get to a jurisdiction that you think is going to give you the best and quickest remedies. And I can give you an example of some of these kind of difficulties or challenges, in that there was a 2020 UK case called Celgard versus Shenzhen Senior. Celgard was a US company. Shenzhen Senior is a Chinese company. It involved battery technology. Most likely the actual first misappropriation of a trade secret happened in China, because the ex-employee of the US company went and worked for the Chinese company Shenzhen Senior and disclosed this battery technology. So clearly claims potentially in the US, potentially in China, but there was a decision to actually issue proceedings in the UK. Why? Because at the stage or the critical piece of the jigsaw that the claimant was worried about is that there was a whole load of batteries being shipped over from China that were about to flood the market in the UK. So they wanted to get an interim injunction in the UK. So that's where they started their claim, and they actually managed to get an interim injunction. It went to, at first instance, it also went to the appeal court. An interim injunction was awarded under the trade secrets regulation. And I think, I only mention that because it sort of demonstrates quite nicely the different jurisdictional bits to a trade secret claim, and how you tend to pick your jurisdiction where you make that claim. The largest damage at that time was in the UK, and the UK courts on that basis said that they had jurisdiction to deal with it, and they did, and they did quickly. So it was a good result.
Brilliant, thank you for that answer, Jamie. Now, I think this is quite an important question, as we've had a few people write in about this, and that's the choice between trade secrets and patents or publication in the freedom to operate context. So if I could hand over to the panel to discuss this, and I think we may have time for one more question after this.
I think it's my turn to take one of these.
Francis, I think
Can't hear you.
What about now?
Perfect.
Great.
Brilliant.
As I was saying, sorry, I must have lent on my thing there. So the use of having your own patent application in the context of freedom to operate is that if you filed your own patent application, in general, someone can't come along later and patent the same thing and stop you doing it. So it's a quite a limited freedom to operate that you get from your own patent application, but it is there either from a patent application publication or from a publication that you make in general. In contrast with a trade secret, because you've kept it secret, you haven't stopped anyone else patenting. So someone could go ahead and later on patent what you're doing through independent development, for example, or in fact because they've stolen it. But say they've done it through independent development. They've got a patent, it covers what you're doing. What are your defenses? If you've got a trade secret, your defense is going to be prior user right. As long as you can prove that you were doing it before they filed the patent application, then you have a kind of limited continuation right to carry on operating. But it's not transferable, it's quite a limited kind of right. So in that sense, for freedom to operate, there's a kind of limited freedom to operate conferred by having your own patent application. It doesn't really replace looking at other people's patent applications and seeing what's out there that could be used against you. Anything to add, anyone else?
Brilliant, thank you. Thank you, Francis. Just taking a look at the time, I think we have time for one more question, which is sad because we have had a lot of questions in that have been fantastic, but these will be sent on to the panel and you will get an answer to those questions if we're able to. Jamie, I'll hand over to you to finish. This is a question from Monique. Can you speak more to misappropriation plans? What should the key elements of a misappropriation plan be?
Sure. So in 1 minute, I think, the purpose of a misappropriation plan is really to have something in place, because when trade secret infringement, that's the wrong word, sorry, trade secret misappropriation takes place, you've got to act really quickly because you want to contain it as much as possible. So having a plan in place to know who's going to deal with stuff internally, who you're going to go to externally, what happens depending on which jurisdiction the misappropriation may happen. That's not just about legals, that can be comms, because there may be comms that have to be dealt with. And it's really just trying to get your house in order as much as possible, so that when the worst happens, you can kind of mitigate the damage as much as possible.
Brilliant. Thank you very much, Jamie. We have just gone over the hour. So with that, I want to thank you again to our panel. Their contact information is there in front of you, so please do reach out. But thank you for your time today and your expertise. And also to our audience, thank you for being with us. We really appreciate it. Have a lovely rest of your day. Goodbye.